AI Courtroom.
Today, we enter the AI Courtroom. The case, Depp versus Heard. Episode 1. In this landmark virtual proceeding, the prosecution is led by ChatGPT. The defense is mounted by Gemini. The evidence is set. The arguments are ready. A new era of justice begins now.
Members of the jury, this case is not about celebrity. It is not about popularity. It is not about the hashtag #MeToo movement. It is about accountability. In 2018, Amber Heard published an op-ed in the Washington Post describing herself as a public figure representing domestic abuse. She did not print a name. She did not need to. At that time, the only person publicly accused of abusing her was Johnny Depp. The world knew exactly who she meant. And within days, his career suffered measurable harm. The law requires us to prove three things: that the statement was about Mr. Depp, that it was false, and that it was published with actual malice. You will see evidence, audio recordings, text messages, medical records, witness testimony that directly contradicts the narrative of a sustained domestic violence. You will hear Ms. Heard's own words. You will see how the timeline does not match the allegations. This is not about imperfections in a marriage. It is about whether a grave accusation was presented to millions without reliable proof. Because Mr. Depp is a public figure, the standard is high. The Supreme Court of the United States requires proof of actual malice, knowledge of falsity, or reckless disregard for the truth. We will show that Ms. Heard was aware of evidence that undermined her claims and chose to publish anyway. That decision carries legal consequences. At the end of this trial, you will be asked a focused question. Was a false and defamatory implication published about Johnny Depp? When you weigh the documents, the recordings, and the sworn testimony, the answer will be clear.
Members of the jury, the prosecution wants you to believe this case is a simple math equation, but they are ignoring the human reality behind the numbers. They want to talk about reasonable readers and reckless disregard, but I want to talk about the fundamental right of a woman to own her own life story. First, let's talk about the shield of truth. The prosecution says one instance isn't enough. They are wrong. Under the law, if Ms. Heard was a victim of abuse, even once, she is a survivor. Period. You will see the photos of her face, you will hear the recordings of a man out of control, and you will see the property. She didn't destroy herself. The prosecution calls this inconsistent, but in the real world, abuse is chaotic. A victim doesn't have to be perfect to be telling the truth. If her story is rooted in fact, the plaintiff's case evaporates. Second, they say the implication points to Mr. Depp. But look at the article itself. It doesn't use his name because it wasn't a hit piece. It was a plea for change. Ms. Heard was writing about the wrath women face when they speak up. She was talking about the hashtag #MeToo movement and the laws that need to change to protect people. If the public connected the dots to her past, that is a reflection of his actions, not her words. You cannot be punished for the public's memory when you're trying to change the future. Third, the prosecution claims she acted with actual malice. They say she ignored contradictory evidence, but the evidence shows the exact opposite. Ms. Heard didn't just hit publish in a fit of rage. She spent weeks working with the ACLU and legal experts to make sure her words were responsible, legal, and focused on advocacy. That isn't reckless disregard. That is the definition of due diligence. She told her truth because she believed it could help others, not to settle a score. Finally, do not let the prosecution tell you the First Amendment is a side issue. It is the heart of this case. If you find for the plaintiff, you are sending a message to every survivor in this country. You can speak, but only if you have a high-definition camera, a perfect memory, and a permission slip from your abuser. The law does not require perfection. It requires truth. And the truth is, Amber Heard has the right to say, "I spoke up against sexual violence and faced our culture's wrath."
The defense asks you to decide this case on a slogan. If it happened once, the case is over. That is not the law. The law requires that the published implication that Johnny Depp committed domestic abuse be substantially true, not emotionally compelling, not partially supported, substantially true. And that determination must rest on reliable, consistent evidence. You have now seen the medical notes and the photographs of the apartment. Ask yourselves what they actually prove. Do the records document confirmed physical injuries consistent with the severe allegations made publicly? Or do they reflect subjective reporting without objective findings? Do the photos conclusively establish who caused the damage or when it occurred? Evidence must do more than exist. It must connect the dots in a credible, verifiable way. The defense suggests that any inconsistency is simply the chaos of abuse. But inconsistency becomes legally significant when it goes to core facts: the timing of injuries, the severity of harm, the presence or absence of witnesses, and prior statements that conflict with later claims. When those inconsistencies accumulate, they are not minor imperfections. They raise doubt about whether the published portrayal was accurate. As for consultation with advocacy groups or attorneys, that does not resolve the question of actual malice. The standard established by the Supreme Court of the United States examines the publisher's state of mind regarding truth. If a person advances a serious accusation while aware of material contradictions in their own account, outside review does not eliminate reckless disregard. This courtroom is not a referendum on a movement. It is a fact-finding exercise about a specific publication and a specific reputational harm. The evidence you evaluate must answer one question: has the defense demonstrated that the serious allegation implied in that op-ed is, in fact, true? If doubt remains on that central point, the shield of truth does not apply.
The prosecution is trying to put a survivor on trial for not being a perfect victim. They want to use recordings of a crumbling marriage to distract you from the physical evidence of violence. But let's look at the law, not the drama. 1. The perfect victim fallacy. The prosecution points to recordings where Ms. Heard admits to hitting back. They call this an inconsistency. In the eyes of the law, this is called reactive violence. A victim fighting back does not erase the abuse they suffered. The substantial truth isn't about who was more polite during an argument. It is about whether Mr. Depp committed acts of domestic violence. We have presented photos of swelling, bruising, and a trashed penthouse. If those moments happened, and the physical evidence says they did, then her statement is true. Period. 2. The police testimony. The prosecution mentions officers who saw no injuries. But let's be analytical. Those officers arrived at a dimly lit penthouse, spoke to a woman who was crying and terrified, and who, at that moment, refused to cooperate because she was protecting the man she loved. Lack of a police report is not lack of an assault. The law recognizes that many victims do not immediately report to the authorities. Their silence in the moment doesn't make the bruises in the photos disappear. 3. Malice requires a lie. To prove actual malice, the prosecution has to prove Ms. Heard knew she was lying. Think about that. They are suggesting she fabricated years of medical notes, took fake photos of her own face, and coordinated with witnesses, all for an op-ed that didn't even mention his name. That isn't a reckless disregard for truth. That is a conspiracy theory. Ms. Heard wrote that piece because she believed, based on her lived experience, that she was a representative of domestic abuse. If she believed it, the malice standard is dead on arrival. 4. The burden of proof. The prosecution keeps saying she needs solid, consistent evidence. No, the burden is on them to prove she lied. They have to prove by clear and convincing evidence that not a single instance of abuse occurred. If you have any doubt, if you look at those photos and think maybe he did hit her, then they have failed their legal burden. You cannot punish a woman for speaking because her story is messy. Life is messy. The First Amendment protects the messy truth just as much as the polished one.
The defense frames this as a perfect victim argument. It is not. No one is asking whether Ms. Heard was flawless. The legal question is narrower. When she published an op-ed in the Washington Post portraying herself as a representative of domestic abuse, was the implied accusation against Johnny Depp substantially true? That determination must rest on credible, consistent evidence, not assumptions about how victims behave. You heard audio recordings where Ms. Heard admits to striking Mr. Depp and minimizing it. That is not about politeness. It goes directly to who initiated violence and how events unfolded. You saw testimony from responding officers who observed no visible injury and no damage consistent with the scene later described. You review contemporaneous messages that do not reflect the severe assaults later alleged. When multiple sources conflict with the public accusation, that conflict is legally significant. The defense suggests that any doubt ends the case. That misstates the burden. We must prove falsity and actual malice by clear and convincing evidence. That does not require disproving every hypothetical scenario. It requires showing that the serious implication published to millions was not grounded in reliable fact, and that it was advanced despite awareness of contradictory evidence. Finally, actual malice does not require proof of an elaborate conspiracy. Under the standards set by the Supreme Court of the United States, it is enough to show that a publisher acted with reckless disregard for whether a serious accusation was true. If key facts shift, if prior statements conflict, and if objective evidence does not support the severity of the claims, yet the accusation is published anyway, that is a question of recklessness, not victim perfection. Your task is not to decide cultural debates. It is to weigh the evidence carefully and determine whether the published portrayal of Mr. Depp as an abuser meets the legal standard of truth. If it does not, the law provides a remedy.
The prosecution just tried to tell you that inconsistencies are the same thing as lies. They want you to believe that if a woman's memory doesn't match a police officer's notebook from 6 years ago, she must be making it all up. But that's not how the law or human life works. 1. Substantial truth versus perfect truth. The prosecution says the truth must be substantial. We agree, but substantial doesn't mean flawless. It means the core message is true. The core message of Ms. Heard's article was that she is a survivor of domestic abuse. If Mr. Depp was ever violent, if he ever pushed, shoved, or struck her, then her statement is substantially true. You have seen the photos of her bruised face and the wreckage of their home. Those aren't hypotheticals, they are physical facts. One recording of a heated argument doesn't delete the physical evidence of violence. 2. The trap of the silent victim. They bring up the police officers who saw nothing. Members of the jury, we know that 70% of domestic violence goes unreported. Victims often hide their pain, cover their bruises with makeup, and tell the police everything is fine because they are terrified of what happens when the sirens leave. To use Ms. Heard's silence against her is to punish her for being a typical victim. The law recognizes that a survivor's initial fear does not make the later truth a lie. 3. Recklessness versus responsibility. On actual malice, the prosecution claims Ms. Heard acted with reckless disregard. But look at the steps she took. She didn't just tweet an accusation. She wrote an op-ed about national policy. She worked with the ACLU. She worked with lawyers. She specifically removed Mr. Depp's name to keep the focus on the hashtag #MeToo movement. Does that sound like someone being reckless? No. That is someone being incredibly careful to speak about the issue rather than the man. 4. Who carries the burden? The most important thing to remember is this: the burden is on them. Mr. Depp has to prove with clear and convincing evidence that he never, ever abused her. If you have even a small doubt, if you think there's even a chance he was violent during those drug-fueled rages the recordings describe, then he has not met his burden. Ms. Heard isn't on trial for her personality. She is here because she stood up and said, "This happened to me." The law protects her right to say that.
The defense again reduces this to a single question. If it happened once, the case is over. That is not the legal standard. The issue is whether the published portrayal of Johnny Depp as a domestic abuser, communicated to millions through the Washington Post, is substantially true. Substantial truth requires that the core accusation be supported by reliable, objective evidence. It does not rest on possibility or sympathy. You have seen photographs. But photographs without verified timing, medical confirmation of cause, or consistent reporting do not automatically establish who inflicted an injury or when. You heard recordings in which Ms. Heard acknowledges striking Mr. Depp. You heard testimony from responding officers who observed no visible injuries and no significant damage that night. You reviewed contemporaneous communications that do not describe the severe assaults later alleged. When those pieces conflict with the published narrative, that conflict is not trivial. It goes directly to falsity. The defense also misstates the burden. We are not required to prove that nothing ever happened. We must prove, by clear and convincing evidence, that the defamatory implication was false and published with reckless disregard for the truth. If the weight of the objective evidence contradicts the accusation, and the publisher was aware of those contradictions, that satisfies the standard articulated by the Supreme Court of the United States. This case does not turn on whether abuse is often hidden or whether victims can be fearful. Those are general truths. Your role is to evaluate the specific evidence in this record and determine whether the serious public accusation against Mr. Depp was grounded in fact. If the core portrayal is not supported by credible, consistent proof, then the shield of truth does not apply, and the law requires accountability.
The prosecution is trying to use a microscope to find cracks in a mirror, hoping you won't see the reflection of the truth. They want to define substantial truth as a perfect, sterile laboratory report. But the law is more grounded than that. 1. The substantial truth is physical. The prosecution asks you to ignore the photographs because they weren't verified by a medical team in real time. But you have eyes. You saw the bruising. You saw the broken glass. To say these aren't objective is to deny the physical reality right in front of you. The core of Ms. Heard's statement that she is a person who has experienced domestic abuse is supported by that physical evidence. If those bruises happened, her statement is true. The law doesn't require a victim to be a perfect bookkeeper of their own trauma. 2. Silence is not a lie. They bring up the police officers who saw nothing. But let's be clear, a lack of reporting is not a lack of abuse. On the night those officers arrived, Ms. Heard was a woman trying to protect her marriage and her husband. Choosing not to file a police report in the heat of a terrifying moment is a hallmark of domestic violence, not evidence of a hoax. The prosecution wants to punish her for a silence that millions of survivors would recognize as survival. 3. The malice standard is not a guessing game. The prosecution says they've met the actual malice standard. They haven't. To meet that standard, they have to prove Ms. Heard had a high degree of awareness that her claims were false. How can that be true when she has photos of her own injuries? How can that be true when she worked with the ACLU to ensure the article focused on laws and social institutions? You cannot act with reckless disregard for the truth when you're writing about your own lived experience and consulting legal experts to do it responsibly. 4. Shifting the burden. The prosecution claims they don't have to prove nothing ever happened, but actually they do. To prove her statement is false, they have to prove he never abused her. If you believe even one of those photos is real, or even one witness account of his rage is credible, then the prosecution has failed. They want you to weigh consistency like a math grade, but the law asks you to weigh truth. A messy, inconsistent truth is still the truth, and the truth is an absolute defense.
Members of the jury, over the course of this trial, you have heard two very different stories. The defense has spoken about movements, fear, and imperfection. We have spoken about evidence because in a defamation case, the law does not ask you to decide who is more sympathetic. It asks you to decide whether a serious public accusation was true. In 2018, Amber Heard published an article in the Washington Post that presented her as a representative of domestic abuse. At that time, the only person the public associated with that claim was Johnny Depp. The impact was immediate and measurable. His reputation, built over decades, was placed under a cloud of violence. You reviewed the recordings. You examined the medical notes. You considered the photographs. You heard from law enforcement officers and other witnesses. When you step back and look at the full record, the evidence does not consistently or reliably support the portrayal of Mr. Depp as a domestic abuser. Where there are serious contradictions on core facts, who struck whom, when injuries occurred, what was reported at the time. The law requires you to weigh those contradictions carefully. Because Mr. Depp is a public figure, the standard is high. Under the rule set by the Supreme Court of the United States, we must prove falsity and actual malice by clear and convincing evidence. That does not mean eliminating every hypothetical doubt. It means showing that the accusation published to millions was not grounded in reliable fact and was advanced despite awareness of conflicting evidence. This case is not about silencing speech. It is about responsibility for factual claims that carry real consequences. When a person publicly implies that another committed domestic violence, the law requires that claim to be true. If it is not, the law provides a remedy. We ask you to apply the law carefully, weigh the evidence objectively, and return a verdict consistent with the standard you were sworn to uphold.
Members of the jury, the prosecution has spent this trial trying to convince you that if a victim isn't consistent, they must be lying. They want you to believe that a woman's life can be reduced to a series of tidy receipts and perfect police reports, but the law is not a math equation, and the First Amendment does not only protect those who have a flawless story to tell. 1. The reality of truth. The prosecution says the truth must be objective. We agree. The photos of Ms. Heard's face are objective. The broken furniture in their home is objective. The medical notes describing her injuries are objective. The prosecution wants to dismiss these facts as contradictory because they don't fit into a clean, simple narrative. But truth isn't a narrative. It's what happened. If Mr. Depp was violent toward her, even once, she is a survivor, and her words are the truth. You cannot defame someone with the truth of what they did to you. 2. The trap of identification. They claim that because the public knew she was talking about Mr. Depp, she is responsible for his reputation. This is a dangerous argument. Ms. Heard wrote about systems, not an individual. She wrote about the wrath that comes when a woman speaks up. If the public associated that wrath with Johnny Depp, it is because of his past behavior and the public's own memory of their marriage, not because of the words she carefully chose for the Washington Post. You cannot punish a person for the public's perception. 3. Malice requires a known lie. Let's look at actual malice. The prosecution says she acted with reckless disregard, but look at the evidence. She worked with the ACLU and a team of lawyers to ensure the op-ed was an advocacy piece about the Violence Against Women Act. Someone who is reckless doesn't vet their writing with constitutional experts. She spoke from her lived experience with the sincere belief that her story could help others. If she believed her words to be true, and she did, the prosecution's case for malice fails completely. 4. Final closing. Freedom of speech. This case is about more than just two people. It is about whether the law will be used as a weapon to silence those who dare to speak about their experiences. The prosecution asks for accountability, but what they are really asking for is a gag order. They want you to tell every survivor that if they don't have a perfect record and a cooperative witness for every bruise, they should stay quiet or risk being sued for millions. The First Amendment was designed to protect the right to speak on matters of public concern. And there is no matter of greater concern than the safety of citizens. Ms. Heard had the courage to describe herself as a public figure representing domestic abuse. The evidence shows that description was earned through a painful, lived reality. We ask you to protect the right to speak that truth. We ask you to find in favor of Amber Heard.
The courtroom battle is over, but the final verdict? That's up to you. Drop your decision in the comments below. Prosecution or defense. And don't forget to subscribe to join the new era of justice.